Chapter 17, Learning Objective 6, Plan for the distribution of your estate, and if needed, use trusts to lower estate taxes. The second part of that is for the people that are a whole lot wealthier than most of us. Trusts are very expensive to create and administer, so if you're not wealthy, you're probably not going to need to worry about it. So how is your estate transferred? I mean, what we're talking about is commonly referred to as estate planning. So there are a lot of different ways to handle it, and what we're going to talk about is a lot of different ways where you can transfer your estate without going through the court system or probate. So, which is the first probate refers to going through the probate court system. Probate is a court system that's specifically charged to conduct the distribution of assets for people who have died. The probate court is a supervised process that allows creditors to present claims against an estate and ensures the transfer of a decedent's assets will go to the rightful benefit. Decedent means the person that has died. Non-probate property is simply property that does not go through probate. Most of your estate can be set up as non-probate property and avoid the headaches and the legal expense of going through the probate process. So you bypass the probate process. The figure 17.1 is how to distribute your estate. So the left side is your non-probate property. It is transferred at debt before your estate goes through probate or to probate court. You implement these steps. You set up contracts that you had prior to your death. First with beneficiary designations on life insurance and retirement plans. You can also put beneficiary designation on retirement assets and bank accounts and so forth. Many of these things can be set up. You can also do the next one, assets owned by joint ownership with rights of survivorship. In most cases, this is the way spousal assets are set up, but you can also do this with your children. You put, and finally, payable at death clauses on bank accounts, but you can also you can also put your spouse or your child on your bank account as a signatory, and make sure you've designated them with rights of survivorship, and they will receive these assets. And the second part, here setting up trusts that designate who will receive the property. Again, this is for the very wealthy. The probate all refers to your will and all the assets that are transferred through the courts to you. So this is, probate again deals with your assets that you are not able to transfer through non-probate methods. So, transfers by beneficiary contract designation. Simply go and you put your beneficiary's name down. A lot of brokerage accounts allow you to do it online. In the state of Texas, if you're going to designate somebody other than your spouse will have to sign that beneficiary contract, the beneficiary designation, because the state of Texas is a community property state. Beneficiary can be a person or an organization designated to receive that benefit or that account. It could be life insurance, it could be retirement assets, bank accounts, and so forth. The beneficiary designation is a legal form signed by the owner of the asset. provides that the property goes to that person or organization at the time of or upon the owner's death. You can also designate contingent or secondary beneficiaries. These beneficiaries would receive the asset in the event that the primary beneficiary has died or no longer exists. You can transfer by property ownership contract designation as well. You need to make sure that it's set up with joint tenancy with right of survivorship. Each person owns the whole asset and can dispose of it without the approval of the other owner. So this allows the asset to pass to the surviving spouse or surviving child or something, or whatever the beneficiary doesn't necessarily even have to be a relative. But if you add them to the title for that property, it could be a home, it could be a vehicle, it could be any number of items like that. There are also transfers by payable death contract designation. This status is granted to individuals who are not joint tenants, who might need access to accounts and so forth without going through probate. You can do this with bank accounts, or you can simply put that individual's name on the account. The rest of your estate, whatever's left over, can be transferred via will. Your will is going to provide instructions to the court as to how to dispose or distribute of your assets. Transfers with a will go to your desired heirs. The testator is the writer of a will or an owner of the estate. So if you are writing a will, then you are the testator, the owner of that estate. Executor is someone that you appoint that's responsible for carrying out your wishes or the provisions of that will, manage the assets until it's passed on to the heirs. Codicil is just a legal instrument with one can make minor changes to a will. Guardian is hopefully you know this, person responsible for caring for and raising any child under the age of 18. So if managing the child's estate, in the event that you have minor children, your will should appoint a guardian and provide instructions for the guardian. Letter of instructions is letter of last instructions, a non-legal instrument that may contain suggestions and recommendations that are useful to the survivors. The court may look at the letter of last instruction to gain clarity into how assets are to be distributed. Without a will, you will have died intestate, and there's a chance that your property may not go to your desired heirs. Without a will, an estate transfers to various relatives according to the law in your state. Could be your spouse, your children, your parents. There's also the right of escheat, which relates to the estate transfers to the state if there are no surviving relatives. In most cases, if there are no surviving relatives, the estate would go to the state treasury. Spouses have legal rights to each other's estates. As I mentioned previously, in the state of Texas, spouses have right to a minimum of 50% of the estate. In the event that you designate a beneficiary on any account that is not your spouse, they would have to sign and approve that beneficiary designation. Community property is what we're talking about. The partnership theory of marriage presumes that wedded couples intend to share their fortunes equally. Community property laws, as I just mentioned, assume the surviving spouse owns half of everything that both partners own during the marriage. Community property consists of property acquired during the marriage, except for separable property, meaning property that was purchased with assets that existed prior to the marriage. You can also use trusts to transfer assets. Trust is simply a legal arrangement through which you designate any or all of your assets to be owned by the trust, either immediately or at some point in the future. Trust can take effect while you're alive. They can take effect after you pass away. There's many different ways for them to work. Estate planning trusts are used to transfer assets and reduce estate taxes. Again, as I mentioned previously, they typically apply to individuals or families that are very wealthy. Okay, I'm going to stop here and create a new video starting at this point.